Companies Act, Section 223, Inspectors Report. Section 223 of the Companies Act, 2013 addresses the procedure for reporting the findings of an investigation conducted by an inspector appointed under the Act. This section provides a clear framework for the submission, content, and accessibility of the inspector's report, as well as its legal standing and authentication. The purpose of this section is to ensure transparency and accountability in corporate investigations and to provide affected parties, such as members, creditors, or other stakeholders, with access to the inspector's findings. 1. Submission of interim and final reports. Subsection 1 of Section 223 outlines the requirement for the inspector, who has been appointed to investigate the affairs of a company, to submit reports during and after the investigation. The inspector may be directed to submit interim reports during the investigation or only submit a final report upon completion of the investigation. The interim reports are typically submitted to provide an update on the progress of the investigation, whereas the final report contains the inspector's conclusive findings and recommendations. Interim reports. The inspector is empowered to submit interim reports to the central government whenever required. These reports provide updates on the investigation, including any preliminary findings, developments, or concerns. If directed by the central government, the inspector must submit these interim reports to keep the government informed about the status of the investigation. Final report. Upon concluding the investigation, the inspector is required to submit a final report to the central government. This final report summarizes the investigation's outcomes, including any findings of wrongdoing, violations of the law, or other issues relevant to the company's operations. It may also include recommendations for further action, such as legal proceedings, regulatory measures, or corporate governance reforms. This dual reporting requirement ensures that the central government is kept informed about both the ongoing process and the final outcomes of investigations, enabling timely intervention if necessary. 2. Form and presentation of reports. Subsection 2 provides instructions on the form and manner in which the inspector's report should be presented. The report must be prepared in writing or printed, as per the directions of the central government. This ensures that the report is formally documented and can be shared, reviewed, and archived in an appropriate format. Written or printed reports. The requirement for the report to be either written or printed allows flexibility, ensuring that the report is prepared in a format that is both professional and accessible. It also ensures that the report meets legal and procedural standards for documentation. Central government's direction. The central government may provide specific instructions on how the report should be drafted or formatted, ensuring that the document meets the required legal and regulatory standards for investigations. 3. Access to the report. Subsection 3 establishes the procedure for obtaining a copy of the inspector's report. Members, creditors, or any other person whose interests are likely to be affected by the investigation's findings have the right to apply to the central government for a copy of the report. Application for access. Any affected party, such as shareholders or creditors, who believes that the investigation's findings may impact their interests, can submit an application to the central government requesting access to the report. This provision ensures transparency by allowing stakeholders to review the findings of the investigation. Ensuring transparency. This access mechanism ensures that the results of an investigation are not kept solely within the confines of the central government or the company. Stakeholders who may be impacted by the company's conduct or the findings of the investigation can review the details and take appropriate action if necessary. 4. Authentication of the report. Subsection 4 specifies how the report should be authenticated to ensure its validity and admissibility in legal proceedings. The authenticity of the inspector's report is critical for its acceptance as evidence in any subsequent legal proceedings. Authentication methods. The report must be authenticated either by the seal of the company. If the company whose affairs have been investigated has a seal, it can be used to authenticate the report. This serves as an official mark, signifying the company's recognition and endorsement of the document. Certificate of a public officer. Alternatively, the report can be authenticated by a certificate from a public officer who has custody of the report. This method provides a formal guarantee that the report is genuine and accurately reflects the investigation's findings. Admissibility in legal proceedings. Once authenticated, the report is admissible in any legal proceedings. This means that the findings and conclusions of the report can be used as evidence in court or other legal forums. The report may be used to support claims, defend against allegations, or assist in the determination of corporate wrongdoing. 5. Exemption from Section 223 for Section 212 reports. Subsection 5 provides a clarification that the provisions of Section 223 do not apply to reports referred to in Section 212 of the Companies Act, 2013. Section 212 deals with the investigation of fraud and the Serious Fraud Investigation Office, SFIO, and it has its own specific provisions for reporting. Therefore, reports generated under Section 212 are exempt from the provisions regarding authentication and access outlined in Section 223. This ensures that investigations involving serious fraud, which may require more stringent handling, are governed by their own set of reporting procedures, separate from those used for other investigations. 6. Purpose and impact of the provisions. The primary purpose of Section 223 is to ensure that the findings of an inspector's investigation are properly documented, authenticated, and accessible to those who have a legitimate interest in the investigation. This provision is essential for ensuring transparency and accountability in corporate investigations, as it allows stakeholders such as members and creditors to be informed about the results of investigations that may affect their rights or interests. The provision for interim reports ensures that the central government is kept updated on the progress of the investigation, while the requirement for a final report provides a comprehensive overview of the investigation's results. The authentication process guarantees that the report is credible and can be used as valid evidence in legal proceedings, ensuring that the findings of the investigation have legal standing. By providing a mechanism for stakeholders to access the report, the law promotes transparency in corporate governance and ensures that companies are held accountable for their actions. The exception for Section 212 reports ensures that investigations related to serious fraud are treated with the appropriate level of scrutiny and legal process. For more details, contact us.